This is a section on legal challenges and legal resources. I begin by telling you that I'm not an attorney and I can't give legal advice, and I don't give legal advice. I can give you information to give you some grounding and some framework to make informed decisions, but this information is not intended to be a replacement for legal advice and should not be considered so. Having said that, let me tell you a little bit about what happens in the event that a creditor sues you. Yeah, they may sue you. You may come to them with a good budget and a good plan. If the budget is high or the balance is high and they feel that they want more money than you can really afford, they may bring you to court. Typically, court, however, comes about when the creditor has been sending you letters or making demands of you or trying to get you on the phone and you've been avoiding them. And you know, I'm a big advocate of talking to your creditor and communicating. When that happens, the only recourse that they have when you won't respond is to send you a summons. A guy going to come knock on your door and say, "Hey, Mr. Warren, Citibank wants to see you in court, 3 weeks from Thursday. You've got, 30 days to respond, and you got to come talk to them because they're tired of chasing you." At that point, the whole composition of the conversation changes, and you need to now go to court. You can go to court on your own. You don't necessarily need an attorney. If you've been, on the other hand, working with your creditor and you've been talking to them, you can go to the judge and say, "Look, I made this plan, Your Honor, and I've been trying to make offers and they won't take them. This is what I can afford, and I've got all these other people I owe money to." Typically, the judges, it's been my experience, will send you out to alternative dispute resolution or a mediator and encourage you guys to talk about how to resolve the debt based on what's in your wallet. And that's really, really good for you. So don't believe that if you're going to go to court just because you're going to get there and it's a big bank, you're going to lose. It's not the case. You have rights just like they do. They have a right to collect the debt. You have a right to say, "I can't pay it, and this is what I can pay, and hey, let's work this out." At that point, they typically get pretty compliant. In the MP3, I will show you 15 places, and sometimes these legal things can take a couple of years. There's at least 15 different points at which you can say to the collector, "Hey, come on, can't we just work this out? I'm tired of you chasing me and me making counter motions, and we're going back and forth and you're threatening garnishments and all this kind of stuff. I mean, seriously, I don't have the money. I mean, come on. At some point, we have to work this out." It's not uncommon for the debt to change hands, to go from one collection agency to another during this process. So don't be upset by a legal challenge. Just know that the most important thing you can do is to respond and to be engaged and to show up. Often, creditors will sue you just because they believe you'll be a default customer, which means you won't show up, and that by default, because you didn't answer and you didn't show up, they'll get a judgment and they'll come after you for the money and get a lien or a garnishment, and that becomes really problematic, but not the end of the story either. There's always a chance for you in court to explain that you can't pay the bill, but this is what you can pay, and this is what you want to pay. You've got rights. I'm Harvey Z. Warren. This is Drop Dead Coach.